היי, ערב טוב לכולם. לייב קהילת מייקר קליבלנד, 22 לאוגוסט 2023. אנחנו מדברים היום על נושא השריף סייל, איך עושים, מה כדאי, עסקאות, טיפים, דברים כאלה. גסטון יקירנו דאג לארגן לנו היום רעיון עם מתווך מקומי שמתעסק פעיל מאוד בנישה הזאת. אז אנחנו בלי מילים ככה מיותרות, אנחנו פשוט נתחיל. Hey Matthew, how are you doing?
Very good, thank you.
Is it Matthew or Matt? What would you prefer?
Matthew is fine.
Matthew is fine. Okay, cool. So yeah, we just start. So please go ahead and do your magic and share the gold nuggets with us.
All right. Well, thank you so much for having me. It is a honor to be here today, and thank you, Gaston, for inviting me. My name is Matthew Klein. I am the principal broker and owner of Walnut Creek Realty in Geauga County, Ohio. Today, I'm going to be speaking with you in regards to sheriff sales, the actual topic and introduction to sheriff sales. So just before we get going, I just have to give this standard disclaimer, but this information provided here within this presentation is for informational and educational purposes only, and it is no way intended to be legal or financial advice. This presentation should not be used as a substitute for obtaining legal advice from an attorney of your choice, licensed or authorized to practice in your jurisdiction. You should always consult a suitably qualified attorney regarding any specific legal question, problem, or matter. Nothing in this presentation is intended to create an attorney-client relationship. Neither the use of nor access to this presentation or use of the information or communication with Walnut Creek Realty creates an attorney-client relationship between you and Walnut Creek Realty. All right, a little bit about myself first and how I came to specialize in sheriff sales. I began my career in 2002 with a company then known as Smythe Kramer Company in Elyria, Ohio. Your experience with Cuyahoga County, most of you that I've communicated with, that's the county west of you. Smythe Kramer today is known as Howard Hanna. In 2005, I began working with broker price opinion providers, and I was providing second opinions for REO properties, the properties that you would see on the MLS, those that were listed as, bank-owned REO and such. I began working as a second opinion agent for those listing agents, giving an opinion of value before the property would be listed. In 2007, I began my career as working as an REO agent, working for the banks. Among some of my clients, you may be familiar with some household names such as JP Morgan, Chase, City Financial, Washington Mutual, which, we blew up and all that. Anyway, I started my career in 2007 as that. In 2012, we had an out-of-state real estate investment firm come into the area. I was interviewed and I became their sole real estate agent for acquisitions. The real estate firm had a very high demand for inventory. And even as an REO listing agent, I had issues meeting their criteria and inventory demands. So in 2015, in order to meet those demands, I began researching alternative acquisition methods, and one of them became the sheriff sales, which is what we're talking about today. I used my knowledge gained from REO and the systems gained from working with the banks in order to develop my systems into processing sheriff sales. In 2018, I received my broker's license, opened up my company, Walnut Creek Realty. We are a small boutique investment property services brokerage. In 2018, we also expanded our sheriff sale research program beyond that one client to a few additional clients. And then in 2022, just last year, the real estate investment firm closed up shop, moving to Florida. Between that time that they were here, 2012 to 2022, in some way, I was either representing or a part of 500 transactions between acquisition and resale with that company. And most of those from 2015 on were done via the route of sheriff sales. So a quick outline here. We're first going to discuss why a sheriff sale, what is a sheriff sale, the requirements for purchase, and what does the online process look like. I'll then cover due diligence techniques. And finally, in the final section, I will cover what I call, I won the house, I paid for it, I got the deed, now what? And I cover 5 different, what I have seen as the most common scenarios that we come across after the purchase has been completed. So first, why purchase at sheriff sale? Well, the sheriff sale offers a unique opportunity to acquire property that is not available on the open market. Sheriff sales have a naturally high barrier to entry. It's steeper than purchasing a property off the open market, for example, in the MLS, where you can call up your agent, go on in, take a look at the property, get typical inspections, appraisals, etc. You won't be able to do that typically with a sheriff sale. So it has a natural filtering effect of reducing the amount of competition. And since it limits the number of competitors due to its strict qualifications and deposits, there are also limited purchasing options. You're not going to be able to conventionally finance FHA or VA a sheriff sale. The most common forms of purchase that we see are either hard money, private money, and cash purchases. And even those cash purchases, sometimes you'll see guys pulling money out of their home equity and such to purchase a sheriff sale. So there is a limited number of competitors, and there is a different segment, if you will, of inventory. So it offers a pretty unique opportunity. What is a sheriff sale? So I've taken this from the Sandusky County, Ohio Sheriff Sale FAQ. The sheriff sales are a sale of real estate ordered by the court to satisfy a judgment entry against the defendant. The proceeds of the sale will be used to satisfy a debt to the plaintiff. Usually this happens when a defendant defaults on a mortgage or loan payment. Until the sheriff receives the order of sale from the court, they are not involved in any of the foreclosure or court proceedings. After the sale is ordered, the sheriff merely acts as an arm of the court to appraise, advertise, and sell the property. So the sheriff's sale is the very end or near the end of the court proceedings in the foreclosure process. There are several different types of court-ordered sales. I have listed only 3 here, as I will cover these 3. The first is a mortgage foreclosure sale via the sheriff. There are mortgage foreclosure sales via the private selling officer. These are very similar in most regards, with a few differences at the very end and how they are processed and advertised. And then there are property tax foreclosures, and those are typically initiated by the county treasurer. So where do you find the sheriff sales? Well, all sheriff mortgage sales in Ohio are now online. You can find them by typing in the following. It's the county name, .sheriffsaleauction.ohio.gov. All 88 counties in Ohio are now online. So if there's a mortgage foreclosure sale in that county, you can simply type that name in and you'll see what that county has available as far as mortgage foreclosures. Now, if you're interested in county tax foreclosures, Cuyahoga County does put those online, but there are many counties that have decided to keep those as in-person auctions. So from Cuyahoga County, the county to your west, Lorain County, the county to your east, Geauga County, both of those have decided to keep the county tax foreclosure sales in person, and they are subject to a little bit to some different rules. If you are going to bid online, And I'm going to specifically use Cuyahoga County for most of this presentation. So if you are going to bid online, there is some basic prep that you need to have done prior to bidding on the property. Your deposit should be sent in prior to the day of sale. If your deposit is not in your account at the day of sale, you will not be able to bid. There is a judicial sale form, which will need to be filled out. Cuyahoga County, they fill that form out automatically for you. They will take the data from your account when you register and automatically fill that out and send it to the court. So be sure that what you have filled in there is accurate. It's very important. Some of the information they're going to ask is if you are purchasing as a business. If you are, they will need the date of the formation of your company, the state of the formation, the business address, and is the business active with the state of Ohio. Now, up until 2020, when these went online, they were in person in Cuyahoga County. And if you were the winning bidder, you would go up to the front, hand over your deposit, and at that point, they would ask you, what's the business name or how are you taking title? If you gave them a business name and that there were two young ladies up there, they would go online at the Ohio business lookup and they would see, is that company registered? Is that company active? If it wasn't, you were rejected right there and then, and you had to make a different company or put it in your own personal name. So that needs to be done and prepared ahead of time. Deed information. They will ask you how the sheriff's deed should read. And then there are actually two questions here. I missed this one, but will you personally occupy the property? And is the property currently a residential rental property? And it is very important that you answer those questions accurately because it will affect what happens if you are the winning bidder after the sale is confirmed and you have paid. This is a look at the judicial sale form. Oops, let me go back there.
Matthew, I'm so sorry. A quick question about what you just said. So yes. I see this question, is this currently occupied property or not? And since it's a no-show and we can't really know what's going on inside the property, we can assume it's vacant or not. But so what should we answer to that question?
Okay, so I've actually have some due diligence techniques in the second section, which I'll relate to you as to how to help answer that. The question of whether or not you will occupy the lands and tenements is one that you should be able to know. But most of the cities that you're dealing with in Cuyahoga County, they have rental registrations. Okay, and I'm going to cover that in the second section. But that is one area that we use when we're doing our due diligence to find out whether or not the property is a registered rental. If it is, then we automatically know, okay, yes, that is it. It will affect how the eviction is done later on, whether or not it is a rental or a homeowner. So it's important to have that to be as accurate as possible.
Got it. Thank you.
You're welcome, ma'am. Okay, so this is the form, and at the bottom you'll see there, I can't seem to move my, there we go. It says all the information provided in this document is true and correct under the penalties of perjury. So I know that there have been cases where, people will put in a nickname when they register their account and stuff like that, and then it will cause all kinds of problems. Don't do that. Just put everything in there as accurately as you possibly can. Okay. So for deposits, this is how the deposits work. The deposits for mortgage foreclosures have been standardized all across Ohio. So all 88 counties for mortgage foreclosures use the same standard. If the property is appraised at $10,000 or less, the deposit is $2,000. If the property is appraised at $10,001 to $200,000, your deposit will be $5,000. And if the property is appraised at $200,001 and above, your deposit requirement is $10,000. Specifically here, it says the plaintiff shall not be required to pay a deposit if it is written in the foreclosure decree. I myself have never seen a plaintiff pay a deposit. Okay. Now this is a special note. If you are looking in, like, say, Lorain County or Geauga County, and you're looking at the county tax sales, the deposit requirements vary. So in Lorain County, for instance, they require 10% of your high bid. So let's just assume for a minute that you want a property at $35,000. Your minimum bid requirement is going to be $3,500. You will have to have that on your person right there in the form of a cashier's check made out to the county sheriff. If you have more, that's fine, but the minimum is the 10%. If you do not have that on your person at that time, they throw out your bid and they put the property back up for auction again. So timeliness of deposits, this is directly here from the sheriff's sale website. If you're bidding in the online foreclosures, mortgage foreclosures, you've got pretty much two choices: an ACH debit transfer, which will take approximately 5 days, or a bank wire transfer, which would take approximately 2 days. And those need to be sitting in your account prior to the day that you bid. Now, I will say this, though I'm not recommending procrastination, I have had clients who have sent out that wire 9, 10 o'clock in the morning, and that evening it was showing up in their account. But I'm thinking that's more the exception than the rule. So be sure that it is there. On their website, they have what they call a deposit wizard, and they'll give you instructions with your bidder number and the county in which it is to be deposited to. So let's just assume here for a second that you were the winning bidder on the property. The timeline currently, if you are the winning bidder from the date of sale, the date you place that winning bid until you actually have title right now, is approximately 2.5 months. Okay. The date of sale is the date that you make your bid. There is also another term that is used. It is called the confirmation of sale. And confirmation is different. So the confirmation of sale will happen approximately 30 days after your date of sale. What the confirmation of sale is, it is the court taking a look at all the advertising, taking a look at everything that was done during the auction, the bids, et cetera, basically looking at the thing as a whole and saying, we are convinced of the legality of the sale, and therefore we are confirming it. At the point that the sale is confirmed, your money, the remainder of your purchase price, will be due within 30 calendar days from that point. At that point in time, when the sale is also confirmed, the plaintiff's office will start to work on the sheriff's deed, and they'll have that delivered, and that's typically within 7 calendar days. After you pay, right now, the wait time is approximately 14 days for the deed to be recorded. Now, it's important to note here, prior to these going online, the county used to let you know in mail that your sale was confirmed. Now they leave it up to you. So you will have to go online to the Court of Common Pleas, put in your case number, look up in the court and see when the sale has been confirmed. And I'll have an example of that in just a moment. When you see decree of confirmation, on whatever date it is, you have 30 calendar days from that date to make your payment. This is what it looks like on the Cuyahoga County Court of Common Pleas website. Decree of confirmation: the sheriff sold the property described in the order of sale issued to him, the court being satisfied of the legality of the sale and that the notice of the sale was in all respects in conformity to law. approves and confirms same, and directs the sheriff to execute and deliver to the purchaser a good and sufficient deed thereof. It goes through most of what we've covered there, but that is what the decree of confirmation will look like. And again, just to reiterate, you have 30 days from whatever date you see that in the court docket on to make your payment in full. This is what it is going to look like for a mortgage sale online for all the counties. This little box up here, it's going to have different addresses, of course, but all the fields are going to be the same. So the case status is the case active in the court docket. Not is the property active for sale. A property can be active in the court docket, and your sale can still be canceled if the defendant, for instance, files for bankruptcy. Proceedings are stayed, but it is still active in the court docket, and proceedings will continue once that bankruptcy is completed. The case number. You use this number to look up the court case in the county docket. I will tell you personally, this is the linchpin of all my due diligence. This number is very important, and everything that you see when you look this stuff up in the court docket, make sure you cross-reference and verify it with what is being advertised here. Or if you see a case number and it's in the newspaper or whatever, look up the court docket and cross-reference everything. Verify it, because there have been instances, and I'm going to name one in just a minute here, where there were mistakes, and those mistakes were incredibly costly to the purchaser. The parcel ID, this is the parcel ID that is identified in the court docket. The property address is also identified in the court docket. The appraised value, this is the county sheriff's appraised value of the home. This is not a standard appraisal. Okay, there's no full interior access, exterior access kind of thing. There's none of that. Most of the time, what is probably going to happen is it's going to be an exterior only, and they may not even be getting out of their car. We don't know. The opening bid is 2/3 of the amount of the county sheriff's appraised value. And then you have the deposit requirement for that particular property, how much money you need in your account in order to bid on it. To the left there, if the property has sold, you will see the highest bid amount and then who it's sold to, the plaintiff, third-party bidder, or judgment creditor. Now, the reason I keep saying this over and over, verify. First, sheriff's appraisals, they are not full appraisals. So do not ever assume they are fair market value appraisals. They're not necessarily even equal to what is in your county taxes, your county tax appraisals. So this is where the opportunity arises for investors, because you have 3 different appraisers going out and more than likely just taking an exterior look at the property, maybe a couple photos, and you're not going to necessarily have an accurate reflection of the value of that property. And then here I have, do not rely on the property address provided as assurance that the address is indeed the property being foreclosed upon. I'm not going to name the county, but I service 8 counties right now. And there is one county in particular which advertised a property for sale. They gave the parcel ID and the property address. The bidders at the auction, if they had done their due diligence, they would have seen that in that particular county, there were 2 addresses that were identical, physical addresses. However, the parcel numbers were different, and so were the property owners. But if you would have typed that address in, just going off of the data that they had given you, the property address, you would have seen a $400,000 house. Type it into Zillow, type it into Realtor.com. Unfortunately, it wasn't the $400,000 house that was up for auction. Right next to it with the same physical address, but a different parcel, was a piece of vacant land. And that's what they were bidding on. And, you know, it would have taken all of 5 minutes at the most to just look at that parcel number, do a cross-reference and check. But instead, the winning bidder paid over $300,000. And to make matters worse, they did not realize it until after the sale was confirmed. Now, they are trying to get their money back. I have no idea how this is going to end up, but I will tell you this. This is months ago. It's still going on right now. Regardless of whether or not he gets all of his money back, he's already taken a loss. He's got court costs. He's got attorney costs. He's got loss of time. He may lose part or all of his deposit. And the other party, this was a tax sale. So the other party on the other side, the parcel owner, is due any of the excess money after all the debts are cleared. So all the court costs, attorney costs, all that, and the property, after all that's cleared, that parcel owner is due the rest of the money in Ohio. So, yeah, I don't know what's going on through that person's head, but it's kind of like, man, I hit the lottery. But we'll see what happens with it. But anyway, that's why I say cross-reference, double-check, verify, verify, verify. Never take that property address as gospel. Always use the court docket and verify what's going on. Okay, due diligence techniques. Now, these are alternative forms of information gathering, some of which are in our toolbox when we do research for our clients on sheriff sales. Right here, rental registration. So we talked about that in the previous section. So this is just one. This is the city of South Euclid. If you go to the cityofsoutheuclid.com/housing, there will be a link there. It will say something like apply to Citizen Serve. Click on Citizen Serve, and then you can pull up rental property registrations. So this is just kind of a screenshot from Citizen Serve. This is the South Euclid one. And then you can pull up the rental registrations, type in the address, and you can see whether or not this property is a registered rental. Another way to do it is to look at the court docket itself. If you see the address in which the service is being made is the same as the homeowner, in other words, the addresses are the same, you are more than likely dealing with an owner-occupant on the home. If the address is different, then you are more than likely dealing with a rental property, in which case you would want to do some secondary verification. Most of these cities, now Citizen Serve is an excellent portal. It is a centralized place for these kind of registrations and stuff like that, even the vacant property registrations. And right now, I want to say it is South Euclid, Shaker Heights, Cleveland Heights, Warrensville Heights, Cleveland, and Lakewood that are all using this portal. So, and I'm sure the other cities, it seems like it's just going to be a habit. Oh, University Heights as well. It seems like they're all going this route. So if you're looking for that kind of information, registrations and stuff, go ahead and type it in there. And if you're still not sure, just call the building department or housing department. I have yet to be rejected on any of my requests when talking to them about, public information, whether it's permits, violations, rental registrations. It may take them a couple days to get the answers back to me, but they have never denied us.
Sorry,
so
how's this website called again?
I'm sorry, ma'am?
How's this website called again? The one that you can see the rental registration and the vacancy and everything.
Citizen Serve is the portal.
Yes,
Citizen Serve.
Okay.
It's all one word. But if you go to your cities like Warrensville Heights, University Heights, if you go to their websites, when you click on like building or housing, something like that, you're going to find a link that each has to their own. Right. Each city has their own database, if you will, on citizens.
All right, thanks. Mm-hmm.
You're welcome. MLS verification of data. So this is an actual screenshot of a property that I was examining for a client in 2019. It was one where we basically could only verify things from the street. Property was occupied and no one's answering the door. There's just no cooperation. So I had to find a way to do analysis on the property and find out what was going on. And as I mentioned previously, I always like to cross-reference and have at least two sources of verification on what I'm looking at. So the first place I go when I'm doing my due diligence is going to be the MLS. Now, if you don't have direct access to it, your broker or your agent, ask them, give them the property address and say, give me the full listing history on this thing. I want to know everything about it. So what I was able to pull from here that was of interest was mostly from the comments. I'm seeing here the home was being marketed with new granite countertops, stainless steel appliances, had a fireplace in the living room, which I think is important, energy efficient replacement windows, new roof, driveway, and 2-car garage. Now I could see the driveway, but with this particular house, the way the garage was situated on the lot, there was no way to see it. So that information was useful. But then I needed another way to verify it, because we all know at times, I'm sure if you've done this enough with the MLS, you found that there has been some data that has just been inaccurate or maybe embellished. So the second place that I went to verify was the county tax. So the auditor. Now this is new, and not all cities are on there yet. And even some that are, their data is not up to date. But if you were to pull up a parcel, there will be a section that says permits. And for this particular property, this is the data that came up. It verified, it was a secondary source of verification for me, the garage, the brand new garage being done, a kitchen remodel, bath alteration. It confirmed for me that there was no AC there, which was in the MLS, and that we were dealing with a boiler system. So I got secondary sources of verification here. And then my last step was to call the city and get a full list of permits and everything that was done on the home. So this was in 2019 that I did this for my client. And I had a full list knowing that this house had been renovated, even though I couldn't see the inside, within the last 6-7 years. So I felt pretty confident, obviously, about knowing what was going on. There's no guarantee. Of course, the house could have been broken into and they could rip out the boiler and all that stuff. There's always going to be that risk. However, I felt pretty confident taking a look at the home, that the home was in pretty good shape and it had all these modifications, some of which were big ticket items, a driveway, a garage. All those things are big ticket items, and they're important, especially when you're dealing with point of sales on the east side cities. All right, a next source of verification, county health boards. Now, there are still some areas in Cuyahoga County that either operate on both well and septic, or well and sewer, or septic and public water. So this may not apply in every single situation, but if you're looking at properties, say in Gates Mills, Moreland Hills, Bentleyville, Hunting Valley, Chagrin Falls, out that way, and even like here with this article, Olmsted Falls, you may run across this. And it's important to make that phone call to know. In this particular case, they were taking septic systems out. They wanted them to disconnect and convert over to sewer. And the cost for doing so to everyone who was in the way of that project was going to be in a tax assessment, as you see in the third paragraph there, of $12,700. So if you're keeping the property as a rental, that definitely affects cash flow. But if you're selling the property, it's going to affect the person that you're selling it to. So it's good to know this up front. And these things, in my experience, they take a while to develop and they take a while to go. But the monetary effect is pretty significant. So it's something you want to be aware of. CCBH.net, that's the Cuyahoga County Board of Health. If the property that you're looking at has a septic or well on it, you can typically get service and installation records for that septic and well. Why is that important? If the property you are looking at has a septic, for instance, Cuyahoga County still has a point of sale on your septic. The fee right now is, I think, $350. So if you're bidding on sheriff's sale, you know you're taking all this risk anyway. A change in a septic system, you're probably looking at $20,000 if you have to do it. It would be good to know the service records. It would be good to know how old that thing is. If that thing was installed in 1950, 1960, you might want to anticipate that that may be a cost that you're going to have to inherit. And also on septics, it's important to note the following. With Cuyahoga County and in the county that I live in, if it's done, a person has to be living in the home for at least 60 days. So what typically happens, I had a client who bought a home in Gates Mills, for instance. It had a septic system on it. And we had to anticipate that that was going to be a cost they were going to have to accrue. When the property was sold to the next buyer, they put money in escrow in anticipation that it may fail. It was like $25,000, $30,000, something along those lines, just in case the inspection failed. If the inspection failed, that money was there in escrow already to fund the replacement of the septic. If not, if it was just repairs, money was taken from that escrow from the repairs. The rest would be sent back to the seller. And if nothing was done at all and it passed, then all that money in escrow is sent back to the seller. So if you're looking at even if you want to buy a home and live out there, it's the same thing. I would definitely do this just to anticipate whether or not that is going to be a cost, because those are significant costs. Municipal housing courts. So this one is a bit of an odd one. This is from the South Euclid Housing Court. And unfortunately for any of these housing courts, whether it's Cleveland or South Euclid, Bedford, the search is a bit of a pain in the butt. It's very hard to find what you're looking for. So we use it the best that we can, but we also know that this is one where we just may not be getting what we need out of it. However, in this particular case for this property, we found that the individual who was replacing his roof and gutters did not pull a permit. We were getting ready to bid on the property, and thus we called South Euclid and said, hey, are we going to be inheriting these fines? You know, can you tell us what's going on ahead of time, just in case we actually inherit this problem? Okay. And you're probably going to get different answers each time, because things like this, especially when they're criminal, as they call this, because that was, you see SPD over there, that's South Euclid Police Department. They're kind of fluid. So whenever you see something like this, always make the call and get a surety on what you're doing. IRS liens. This is a fun one. So what you're seeing here is an actual response from the United States government on a property that my client ended up purchasing. As you see here, the defendant admits that it has an interest in the property, and the total amount of interest was $107,000 plus interest and penalties from the date of assessment, which was in June of 2012. My client bought this particular home in 2015. And if you look at the third defense, the defendant reserves its right to redeem as provided, and it gives you a couple codes. So this is what we were looking at. We were looking at a home which was at a very attractive price. And I talked with my client as soon as we did our research, and we found that there was an IRS lien there. And he asked me, he said, so what does this entail? I said, well, okay, let me go back, do some more digging, and we'll figure it out. So this is what we did. We went directly to the IRS itself. There is the website up at the top, irs.gov, and we took a look at our risks and what would happen. So the Internal Revenue Service has a right to redeem real property sold through a foreclosure action initiated by a third party, typically a bank, that has a priority interest over the federal tax lien. The time for a redemption after foreclosure sale with respect to either a non-judicial or judicial foreclosure is 120 calendar days, or the period allowable for redemption under state law, whichever is longer. We decided not to look any longer than the 120 calendar days to see what Ohio says, simply because this property was one that was going to be acquired as a rental. So he asked me to dig a little bit further. We wanted to see what was the likelihood that the IRS would take this property back. We were looking at a home that at the time in 2015, under its current condition, we thought was worth a maximum of $50,000. The IRS had a lien on it for $107K plus the interest and penalties. And, you know, my initial thought was, it doesn't seem very likely that they're going to pay my client $50,000 to take a property back that's not worth that much, to try and sell it for 107 or more. Didn't make sense, but we decided to be extra cautious and continue looking. This again is from the IRS's website. If the fair market value reasonably exceeds the amount paid by the foreclosure sale purchaser and the amount of all liens senior to the foreclosing encumbrance, consider redemption. If it is less than the amount paid by the foreclosure sale purchaser and or amount of all liens senior to the foreclosing encumbrance, do not consider redemption. So we felt pretty good at that point that this was not going to be a candidate, but my client asked me, what are the repercussions? What if they do? What if they do? Okay, all right, so we'll keep looking. This is what happens if the IRS decides to redeem the property. First, they have to notify you here, as it says in section 1. 2, in addition to being reimbursed for the amount paid towards the purchase, and look at the parentheses there, plus interest, the purchaser has the right to request reimbursement for certain payments made to a senior lien holder if the government redeems the property, and a reimbursement request is submitted that meets the requirements of the regulations. Well, that second part did not, that didn't include us, but the first part did. So I went back to my client and said, well, hey, look, so they're going to reimburse you your purchase amount plus interest if they decide to take the property back. You're going to be keeping this as a rental, and it looks like the maximum time period is 120 days. Do you want to proceed? He said yes. So we did. And ironically enough, that client ended up getting the property for $26,000. So it was even less likely that they were going to come back for that. However, in that particular case, and I'm going to cover this a little more in detail in the next section, he did one other thing to mitigate his risk. Because had he decided to renovate that property and the property value had gone up within 120 days, you never know, right? They could have said, okay, now we're going to try and redeem it. But in this case, what he did was he decided that the occupant that was in there, he would then convert them to a tenant. And I'm going to go over that in the next section a little bit here. A lien search and a title search. So this is coming from Carrie Magno at Title Blue Agency. Carrie is the owner of the company, and this is a company that many of my clients, not all, but most of my clients have decided to use when they are purchasing sheriff sales. So I proposed to her the question, can you explain to me what is a lien, what's the difference between a lien search and a title search? And this is her response. A lien search only shows current liens on the property. It is not insurable. If a title company misses a lien on a lien search, there is no recourse for the buyer to file a claim with the title company. However, if you get title insurance, the search goes back 42 years and is insured by the title company's underwriter. So if something was missed, you can file a claim and the title company is required to fix the issue. Now, I will explain why my clients use a lien search. They are, especially this firm that I was representing for a time, they were bidding on, at any given week, 8, 10, 12 properties. And there was no guarantee that they were ever going to get all 8, 10, or 12. Sometimes we would walk out with 5. Other times we would walk out with 1. It would all depend. and paying for a title search, which would cost you $300+ every time, and you're not guaranteed the property, would end up being a very costly proposition. This is obviously up to the choice of the purchaser, but they decided to go with a lien search instead, which was far more cost effective. And then there were other means of doing your due diligence in order to ensure whether or not all liens were properly served.
Matt, can I ask a question real quick?
Yes, you may.
So when I win the property with Sharif sale, right? So what kind of I cannot do any title insurance, right?
When you purchase, they can, at that point in time, most of my clients, if they are the successful bidder, they will go through a company like Carrie's and get title insurance. But leading up to the bid, because they're not guaranteed the property, in the vast majority of those cases, they just will either call Carrie or another title company and say, hey, can you give me a quick lien search and let me know if everybody who is every lien that's on the property has been properly served?
Okay, let me take you a little bit back with that topic. If I'm the winning bidder on the property, any property, right? So what kind of closing am I going through title company? What kind of closing are you doing? What kind of
you don't have to. You can pay all your money directly to the county sheriff and close it out that way. And some people choose to do that. You do not have to elect to use a title company. With myself and with my clients, you see, I tend to err on the side of caution. I've just seen too many in my time costly mistakes, if you will. And so I always want that extra set of insurance. A sheriff's sale, by its very nature, is a higher risk proposition. And so anywhere that I can look to mitigate that risk or talk to my clients and see if they wish to mitigate that risk, I'm going to go there, right? It's all about mitigating the risk at this point, doing enough research ahead of time, knowing as much as you can about the property in order to be satisfied that if you go in there and bid on it, whether you get it or you don't get it and you lose it by $100, you're happy. My goal for my part on this is to ensure that whether my client is stepping into an auction room or he's stepping in online, that he or she is the most educated person bidding on that property. They have the most knowledge. Therefore, they may not get sucked up into the bidding war, such as the example that I gave you earlier with the individual who ended up buying a vacant parcel for over $300,000, right? So that's the goal here. The goal is to give the client as much of an education as possible. I'm going to cover in the next slide here, I'm going to cover a little bit more on the liens and title.
Matt, I have a question regarding to this.
Go ahead.
When we get the title from the sale, you get a sheriff deed, right? Are you saying that we can change the deed and go to a title company and change it to a warranty deed instead of a sheriff deed? That's what you're saying?
No, you get a sheriff's deed. You get a sheriff's deed. Okay, so when you purchase it from the court, you're getting a sheriff's deed. What I am saying here is with the title company, I tell my clients, get title insurance. Cover yourself.
So that's after acquiring the property, right? After the deed is on your name already.
No, it's before that. So if they are the successful bidder on the property, most of my clients, what they will do at that point is then they will send over their deposit receipt and all the information to whatever title company they're working with. Okay. And then they will say, hey, I want to get title insurance on this at that time. And then the title company is running everything through them, their escrow and everything like that. And in the end, they are running the money down to the county, to the in Cuyahoga County, to the administration building. They're either physically going down there or the money's being wired, however it is, but they're handling the delivery of it. Okay. You get a sheriff's deed. Now, what you do after you get the sheriff's deed, if you want to go ahead and make changes, that's on you. I had a client who made a mistake when he made the purchase of a property and didn't put the name and things on right. And we tried to change it during the court proceedings, and they said, no, not doing it. You handle it afterwards. So after the entire deal was done, we had to go back and go to that title company and say, hey, can we get this changed? The LLC name was wrong, blah, 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 blah. And then they changed it out. So it was no longer a sheriff's deed. It was something else. But you are issued a sheriff's deed at the sheriff's sale.
Yeah, but this is kind of confusing because the plaintiff have like 30 days to redeem the property. So you think you're the winner, you're happy and dreaming of the house and how you cook dinner in the kitchen and everything. But then comes the plaintiff and, redeems the property. What happens now? You started the process with the title company.
You're talking about the defendant redeeming the property.
Yeah, yes. Sorry, yes. Defendant.
Yeah. Yes, that is something that has happened. So if you are the winning bidder, and there is that 30-day period, they can redeem the property, or at that point they can still file for bankruptcy. I actually had one in Cleveland Heights. He won the property in 2019, and the defendant was so skilled at whatever she was doing in court, he did not get title until last year. He could have gotten his deposit back if he wanted to, but the deal was such a good deal that he decided just to hold out and wait her out. She had, a bankruptcy proceeding and some other things happen, and I'm going to wait until it's all done. And then, 3 years later, he gets the property. So yes, that can happen. That can happen. But once the sale is confirmed, at that point, that is when your money's due. You haven't paid any money other than your deposit. Right. Up until the sale is confirmed. So you're holding on to your deposit, $2,000, $5,000, $10,000, whatever it is. And if it's running through those proceedings, you can always go ahead and request. You have to do it through an attorney. Request the money back. They offered my client, the one who waited 3 years, they offered him that opportunity. Do you want to get your $5,000 back? And he said, no, I'm just going to wait. I'm just going to wait it out. And I'll give you one other quick example. It's okay, man. It was in South Euclid of all places, where the city had a vested interest in a property that we purchased. And, I had a pretty good relationship with the city. And when I spoke to them, they said, that was you who bought that property, right? And I said, yeah, it was my client. And they said, well, we really want that thing. We really want it. And I'm like, okay, so what do you want me to do about it? I said, because, we bought it. We'd like to renovate it and fix it up and everything, but you tell me what you want, And so they asked if we would go back to the court and ask to have the sale vacated, and so that they could go ahead and take it back at the next sale, work through I think it was the land reutilization program. So I talked with my client, and he didn't care. We had enough inventory as it was, and we thought it would be a good idea just to stay on South Euclid's good side. So we're like, fine, okay. So we went back to the court, filed a motion to vacate. South Euclid showed up, and they filed their thing saying, hey, this is the reason we want the property, et cetera, et cetera. Got the $5,000 back and moved on. So the sale was never confirmed, right? Okay. What happens to liens on the property? Now, this is coming directly from Erie County. And I am always going to refer to the expert on this. This is Carrie Magno in her previous thing here. You got her contact information. If you have any real specific questions, and even if they're not specific, she is really smart in this area. She's been working with me on this for 8 years now. She's been really good to my clients. So liens are marshaled, placed in order, and paid in order from the sale proceeds. A deficiency judgment is granted to the plaintiff against the defendant. If enough money is not generated at the sale, the liens are then canceled. The information on liens can be found by visiting the clerk of courts. The exception is the federal tax lien, and we just talked about that. That one will continue on a while after you make the purchase. There is another area where a lien may come back. And this, again, I'm speaking from personal experience, where a client had done a lien search and the lien search did not turn up anything. But after he purchased the property, what they found was the title company that was representing the plaintiff missed a lien. Don't know how it happened. They were never properly served. And in that case, my client ended up inheriting that lien. It was a credit card, like $6,000 some odd dollars or something. So my client went back to the title company who did the court proceed, did the preliminary judicial. If you look at the beginning of every court docket, you're going to see where the complaint is filed. You're going to find what is called a preliminary judicial or a pre-judicial, one or the other. And it's going to list in there a title company, and they're going to give out the list of exceptions on the title insurance, which is granted to the plaintiff. I encourage you just to go ahead and take a sample and just read through one of those and just take a look at what it says to kind of familiarize yourself with it. But this one wasn't on there. And so what ended up happening was my client went back to the title company and the law firm who was representing the plaintiff and basically said, hey, you missed this. Now, this situation, I've seen it go many ways. It's always fluid when you're dealing with this. But in this case, he said, you missed this. So what are we going to do? I'm not going to pay this. I'm going to keep the property as a rental. They may never get their money. I'm going to keep it 20, 30 years. So they went back to the credit card company and they began the negotiations. And he pretty much told them, you know, I'm keeping the property. So if you want your money, we need to come to some kind of agreement. In that particular case, that $6,000 judgment ended up being settled for about $900. Okay. That is not to say that that's going to happen every single time. The situations are fluid. I have seen others where the title company bared responsibility and said, it's gone, we'll take care of it, don't worry about it. And then I've seen others where they said, you're on your own, buddy. So the extra set of due diligence, which I always recommend on these is warranted, because you can inherit stuff like that. It is a possibility. Okay.
How about mechanical liens? How about mechanical liens? Do you inherit that? Yes. Do you inherit that, or it's being paid?
Okay, so I'm going to defer to Carrie. I will give you my understanding. Any lien that is on the property that has been served, if there's not enough money there, what it's saying here is that they are canceled. Okay. Now there are situations, and you will want to talk to Carrie about this, or somebody else who's qualified to talk about it, another title company or an attorney. But there are cases where after the foreclosure is filed, someone then at that point tries to file a lien. I don't know what happens there because I have not personally run across it. Most of the time, by the time we're researching these things, it's near the very end and we can see what's going on. Right. So you'll definitely want to have, a real estate attorney or a real estate attorney working with a title company to answer that question for certain. But here, the understanding that I have, and it's been my experience on, is that the deficiency judgment is granted If enough money is not generated at the sale, the liens are then canceled, with the exception, of course, being the IRS lien, the federal tax lien, right?
Mm-hmm.
So these situations are always fluid, which is why I will tell my clients in every single situation, if you are unsure of anything, if you have any doubt at all, if you're not sure, walk away. And never, ever, ever, ever let your emotions get the best of you in this. It's better to miss 1,000 opportunities than, like that guy I showed you at the beginning, make one huge mistake, man, because it can set you back a very long time. It could bury you, right? So if you're never not sure, don't do it. Don't do it. Ask for legal advice. Ask your attorney, ask the title company, or the attorney at the title company, I should say, and get clarification. But never go into one of these if you are not sure of what you're doing and you are confident of what you're doing. It's one of the reasons, though, gentlemen and ladies, why the arena is not, the arena has so many opportunities, because there is a higher risk, right? There is not as much competition in this arena for that very reason. You are taking on more risk. And there are, I would love to say, even at this point, that I've seen everything, but every time I think I've seen everything, something else shows up. So when you're doing this, be aware of that. Be aware of that, and never go into anything you're not sure of.
Matthew, I'm so sorry, but this is
yes, ma'am.
Sheriff Sale. I feel like you cannot be 100% sure. If you're not able to enter the property and see what's inside, and you can look only from the outside, how can you be sure? I mean, I understand all of this, but let's say in my case, if I bid, let's say more than once, I wouldn't spend money on title searches. I don't know how much lien search costs, but this is something you try to, as you said, figure out on your own using all this online information, but you still cannot be 100% sure that you covered all.
No, you never can. Again, which is why this area is a little bit of higher risk, higher reward. I will say this, and I did not cover it in our due diligence for obvious reasons, but I'll say it now just as an aside. One of the things that we do, or that my clients do on occasion, is we actually will go up and we will knock on the doors. And I have a young lady, I think she reached out to Gaston to talk about this. She's been very personable. She's a great gal. She's very humble, and she's oftentimes been able to talk to them and get inside. And once we're able to get inside, we've got a clear view of what's going on in the home. So if you have that courage and you'd like to, you want to go around and door knock,
yeah,
and see if they'll answer the door and get more data. Actually, to be quite honest with you, that has been the way that we have gotten the best deals. Is we will go out, or our clients will go out and do the things that our competition will not do, or they're afraid to do, right? I mean, going out and knocking on a door takes some courage, especially when you know the person is in default, and there are probably a lot of things wrong besides missing the mortgage payments. But at the same time, you get that data. There was a property many years ago in Mayfield Heights where that was exactly the case. We got inside, Devaney talked to them, she took photos, and then she told them, she said, thank you for doing this. And if we win the property, what we're going to do is, we're going to give you an extended period of time to move out. We're going to help you financially with the move out. We knew once we had been inside the home that the county taxes, which most people would have been relying on, were wrong. They were wrong by a lot. There were 2 extra bedrooms and an extra bathroom in the home. And so the square footage and everything was wrong. The problem that I had was, after we bought the property, everyone in that room, when we tried to wholesale it later, at first, or my client did, everyone thought we overpaid, because they weren't working off the same data that we had, because we had actually gotten inside the home. But it turned out to be a major home run for my client. All that from simply knocking on a door, being personable, and talking to someone. And that isn't going to happen every time, but for us, it's happened, I would say roughly 30-40% of the time, the people will at least talk to you. You know, they may not always let you in, but they'll at least talk to you.
I did it once, and luckily the homeowner was outside of the house, just sitting there. And after long conversations, he let me in the house, and it saved me from, because it was in Mentor, it was in good neighborhood, but I wouldn't pay for this house more than 60K. So I ended up not bidding, and the bidder, the third party, won it for $108,000, and I feel like it's a big miss, just because from the outside the house looks nice, but in the inside it's just terrible.
Yeah. And you're gonna get that, and you're gonna get people who are gonna bid. They're gonna let their emotions get in the way, and you just have to let that happen, right? It's your money. You've worked hard for it. I would not part with that thing easily unless you're sure. And with us, when we do this for our clients, it's all about mitigating as much risk as possible, because we know nothing's ever going to be 100%. It's real estate. Even when you buy a home off the MLS, which, you know, at the beginning we were doing, you start getting into some of these older homes, and then you open up walls, and all of a sudden you find stuff that, ooh, you know, what did we just do? Especially if you're working in homes like Cleveland Heights and Shaker Heights and places like that, that stuff is going to happen. So it's for us, the idea with this was to fill a market need, mitigate as much risk as possible, and eliminate as much of the competition as possible. But if somebody wants to go ahead and do what, you know, you did, or the person that you saw did, or what I mentioned here at the beginning, let them. That stuff kind of has to happen to clear some of the area out, you know? Okay. So after title transfer, I have seen 5 different scenarios, most common, and I'm just going to go through each of these briefly. Now, as I mentioned earlier, I was an REO agent for many years for financial institutions. So a lot of this that I'm telling you comes from my experience there, although there is one case here where I had a client hit an absolute home run on one of these, which I'll explain in just shortly here. So cash for keys. Basically, the idea behind cash for keys is that you are exchanging possession of the property with a cash incentive to get possession of the property, and the occupant, who could be the homeowner, could be a tenant, is turning over the keys to you in exchange for monetary value. Okay. I don't know. I haven't seen any template cash for keys agreements online, but I would not use any of them. I would always run through an attorney on these, because there are angles. There are angles that can be used, and especially in court, perhaps, to be able to create complications for you. So always run these things through an attorney. Both the cash for keys agreement and the release, run it by your attorney, have them look it over, see if they can poke holes in it. Just as some terms and ideas that were used in the agreements that I had with the banks, they would use the properties to be vacated within X amount of days. That was typically a specific date. They would not say 30 days or 45 days. They would say September 6th, 20, blah, 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 you know, whatever year it was. They would use a very specific date. They would also put down the properties to be left in clean, broom swept condition. So this is all your personal property out. Any fixtures that are there, such as the dishwasher, the ceiling fans, things like that, all that stuff stays. But your personal property, your beds, your clothes, all that stuff needs to be out and removed. The property is to be also left with no additional damage not noted in the initial inspection. And what we would do at this point, if that occupant had agreed, is they would agree to allow us to take 2 photos of each room. They were done from 2 opposite angles, so we would get a complete view of the room, and then note any damages, cracked windows, holes in the walls. And then we were always taking photos of the furnace, the hot water tank, the electrical panel, things like that. And then when we would come back at the vacate date, we would take photos again for our client and ensure that everything was in the same condition. So it would be like that cross-reference, right? We look at our old photos, match them up, be sure that everything was the same as it was on the day that we did that. All their personal property is out. If that happened, what we would do then is we would have a release ready with our check. They would sign the release. We would sign the release. They would release over the property, turn over the keys. We would hand them the check. They would leave, and then we would change the locks and move on our way. Utilities, depending upon the condition of the home, it was variable. Some of these places that I had done these for, the gas had already been shut off or something like that, and so it wasn't necessarily a requirement for those utilities to be on. The occupant becomes a tenant. So there are two things here. The occupant is the former owner, or the occupant is a tenant. Now, my client who had come in for a time investing here, one of the ways he mitigated his risk, especially on like the IRS lien property, was he turned around and took the former homeowner and left them in as a tenant. But the way he did his leases was very different. So when he did when they worked in the financials, you know, when you're qualifying your tenant and all that, he did all the financials and everything. He saw that her mortgage payment was far more than what the rent was going to be at that time. So he qualified her, but he put into the lease, you know, more as like, he kind of phrased it as, I'm doing you a favor when he talked on the phone to her, but it was more like, I'm letting you stay in the home. You lost the home, but I'm going to let you stay here. But in return for doing that, if your furnace goes out, if your hot water tank goes out, if anything like that goes out, you're going to take care of the repairs. You're going to pay the utilities every month. You're going to live in the house just as if you owned it. I'm going to leave you here, but you're going to pay the rent to me. And that worked spectacularly. And he actually had, on that particular property, that tenant stayed there for 3 years until he decided it was time to unwind some of his holdings. The second scenario is the occupant is already a tenant. And in that case, you know, it just depends. He would run the same thing, run financials and all that. And a lot of times what we had found was that it was the landlord himself who got himself into trouble. And in some cases, you may find where the tenant is actually putting the rent aside already. They're putting it into escrow or something like that because the landlord isn't doing what they're doing, or there's an active court case, something like that going on. So he used both of those situations, and I've seen a couple other clients do the same thing. So it is an option to consider. This one, I've been in this business 21 years, and I have seen this twice. So it always helps to ask this question because you never know. The occupant actually purchased the home. So there have been 2 occasions, like I said, where this happened. The first, I was representing a financial institution. The occupant was a tenant. They were in an active court case against their landlord who had been neglecting the property. Came by, knocked on the door, introduced myself, told them what I was there for. You know, the owner lost the home, et cetera, et cetera, et cetera. And they said, we would like to buy the home. And I was, of course, a bit skeptical, but I delivered the message back to my client, the institution. And then they said, okay, give us a fair market value of the home. We're going to call another agent. They're going to give us a fair market value of the home. And then we'll get back to you with a purchase price. After that was done, they came back with an offer. They came back with a number. I presented it to the tenants, and the tenants showed me a bank statement, and they had more than enough money to buy that home. So 30 days later, they own the home. The second one is even more rare. This was actually that real estate firm that I mentioned at the beginning. They purchased a home. The home was in Lakewood. And they bought it. And after they bought it, it was sight unseen, by the way. It was only an exterior inspection on this home. something had happened with the occupant. We're not sure what, but when we had come over to the property after my client had the deed to start doing the typical stuff, presenting, you know, either a move out or cash for keys or something of the sort, he mentioned that he would like to buy the home back. And of course, this time I was a little more cautious in my approach. And so we started the conversation. My client said, okay, if he really wants it back, this is what I want. And the number was approximately $60,000 more than what he had paid for it. The occupant apparently had money in the family someplace, retirement funds or whatever. They came up with the money and they bought the home back. We never saw the inside of that home. So the lesson here is, even though these circumstances are rare, if your goal is to either renovate and resell that home or just resell it immediately for a profit, it doesn't hurt to talk to them. Granted, this is probably a once in a lifetime thing that happened, but it does not hurt to talk to them and see if there is something there. You never know. So for them, that was obviously a quick profit on the home. Eviction. So some of my clients here, especially the financial institution ones, they ran an eviction proceeding concurrent with the cash for keys. Now, I will say upfront, consult with your attorney before doing this. The reasoning was, in the case that you perform a cash for keys with a tenant or an occupant, former homeowner, whoever is in the home, and you say, okay, the vacate date is September 30th. And you show up on September 30th and they are no further along moving out their belongings than they were the first day that you met them, you've lost 30 days. So the reasoning was, go ahead, pay the court, begin to file for the eviction, pay the attorney. This way, if something goes wrong, we are not starting from scratch 30 days later. We already have this process in place. And if we get the cash for keys, we simply file a motion for dismissal and that's it, we're done. So that was something that I saw an awful lot with my institutional clients. I did not see that so much at all with my regular, if you will, retail investors. But that was something the banks did use quite a bit. The actual procedure is going to vary, though, depending upon the occupant type and the location of the property. If you have property over there on the east side, South Euclid, Bedford, Shaker Heights, Cleveland Heights, you're probably familiar that each city, each area has a different procedure for how evictions run. So that is why it's important to know up front, if you can, whether or not that is a residential rental property or not, because your eviction may run differently depending upon where that property is located and if the property has an owner or a tenant in it. So I say here, always consult with an attorney before proceeding. The other thing is, like 2020, all of a sudden all the eviction rules and everything changed for a time, and there were moratoriums on everything. There was eviction moratoriums, foreclosure moratoriums, all that stuff. So for my clients, I have always recommended and will continue to recommend using an attorney. They are worth their weight in money. They can save you a lot of money and a lot of headaches. This last one, vacant and abandoned. So I pulled this directly from Weltman, Reinberg, and Reese. This is a law firm that had represented some of my financial institutional clients. So what happens here if you find a property that is quote unquote vacant and abandoned, but there's still property left in there? Can creditors discard personal property following a foreclosure in Ohio? So what I was told, and what this article says here from this law firm, Ohio does not have a statute governing the disposition of personal belongings left at the property. The only legal remedy would be to commence an eviction, and there is no legal process in place to have the personal property discarded in lieu of an eviction. Okay, so what I talk about with my clients on this is just run the eviction. If you're ever in doubt, just run the eviction. I have seen people do the quote, as they talk about here, the self-help method. You know, for the most part, the results have been mixed. It just depends upon the situation. But what I have always said and what my clients typically have done in the institutional area when we see something like this is just run the eviction, be on the safe side. That way you've got a little more assurance that there's nothing coming back to you at the end. If the sheriff shows up, they break the locks, they do, or not, they don't break the locks. You have someone there breaking the locks for you, but then they go inside, they do their thing, and they tell you at that point what to do with the property. You're following the sheriff's instructions at that point. You've got yourself covered, if you will. So in this instance, if I see something like this, that is what I'm telling my clients to do. You know, go ahead and just finish the eviction. Don't take any chances. Final thoughts. When you're doing something like this, which is sheriff sales, and they are higher risk, higher reward, get an experienced team around you. I have had clients make a lot of money doing this, but there is, of course, also a lot of extra risk being taken here. So get competent and qualified help. I have some clients who will run opinions off of several title companies, and I think that's a good idea. Don't talk to just one, talk to a couple. And they do the same thing with attorneys. They're getting a multitude of opinions to cover themselves and to get the best advice possible as to how to move forward. Some of the situations that you will find are very fluid. And you may say, boy, I've never seen this before. This is the first time I've gone through this. But in my career anyway, I can say this is the first time I've gone through this a lot, because it seems like every time I'm in the business here, it never fails. At least not a year goes by that I'm not seeing or learning something new. So get multiple opinions, get good attorneys, get qualified title companies, bounce all your opinions and your thoughts and your doubts off of them in order to save yourself a lot of money and on a lot of headaches if you want to pursue this route. The opportunities are there, but it's precisely because the barrier to entry is higher and the risk is higher. And thank you guys. Thank you so much for letting me come to speak today. I really appreciate it. At any time, you can contact me. My email is right there. My phone number is there. I have 2 websites right there. One of them is from the time when I was working with the banks, the Ohio REO experts, and then the other is my current company website. Thank you.
Sure. Matthew, thank you so much. I have a few questions, if I may.
Yes, ma'am.
Could you please recommend an attorney?
Would I please recommend an attorney?
Yes.
Technically, I would have to give you 3, and I can do that. If you want to reach out to me here, I don't have their information with me right now.
Yes,
but if you want to email me,
yeah, I'll email you, and thank you very much ahead of time for that. Another question that I have: when is the best time? So you did mention it. I just feel that I didn't really quite get it. When is the best time to do a title search on the property? So in my specific situation that I'm in at right now, I won this property via auction, via sheriff sale of Cuyahoga County in May. I still didn't get it because there was a motion on the house, and I'm supposed to get the deed in a couple of weeks because it's already after the motion, after the magistrate signed and the judge. So is it now already a good time to do a title search? A title insurance, or just after I get the deed?
Okay, let me answer that in two parts. First, in our processes, what we do is right before bid, we would order the lien search. At that point, because up until the point that the property is up for sale, anybody can come in at the last minute. And I'm sure you guys are aware, and if you're not, it's very easy to file mechanics liens in Ohio. It's ridiculously easy. It doesn't mean they're going to hold. It's just anybody can do it. So we typically wait until the very last before we order the lien search and see what's going on in the property, just in case something else shows up right at the very end, right? So with your situation now, you have already bid on the property and you've won the bid, correct? That's what I'm understanding?
Yes.
Okay. I would suggest that I don't know if you have a regular title company that you work with or not, but I would suggest either talking with them. I can give you, of course, I can go back on the slide and give you Carrie's information, or give you a couple other title companies if you wish who are experienced in this. But I would definitely, if it were me, if it were my purchase, I would be having somebody take a look at it. Even though you're beyond that point, it's still good to know what's going on so you can kind of anticipate what you're going to have to do, right?
Got it.
The house
what
that I
about the
live
insurance?
in. What's that?
The title insurance.
Yes. Have them take a look at it and see if they can issue a title binder even at this point. A title insurance at this point. Yeah, talk with them and see if they can still do that.
Got it. Okay.
I don't see why they wouldn't be able to, but yeah, definitely have that conversation and see if you can get all your bases covered.
All right.
The house that I live in, I purchased at sheriff's sale.
And
wow. The procedure that I've been saying here a lot about the title, the lien search, and all that stuff, I followed the same exact procedure all the way up until, of course, we purchased the property, and then I got my title insurance after we were the successful bid. Okay, right. So it's I don't see why they couldn't, but go ahead and have that conversation with them.
Got
and
it.
See, and then if you want 3 different title companies as well, when you email me, I can do that, of course, for you as well there in that same email.
Gotcha. All right, Matthew. And like a technical question, do you know auction.com website?
Yes, ma'am.
Is it similar, like everything that goes out on the sheriff sale also goes out on auction.com, or there are different properties there?
No, there are different properties there. I didn't really cover that in much detail. You're going to see some overlap because some of those banks use auction.com as a advertising front, if you will, for the sheriff sales. But what you will also see on auction.com is some private selling officer sales. So there's a guy out here, and I can't remember his name right now, but he's one of the private selling officers in Medina County. And he does a lot of his private selling officer sales, which are similar to sheriff sales. They're just not going to happen on the sheriff sale website. They're going to happen on auction.com, right? And they're going to follow, I think on those, it's a 7-day period. So they're going to be open for bid for 7 days. So you'll have to pay attention when you're looking at those properties to see if that is a private selling officer and who the auctioneer is. And then the other thing you're going to find there is properties that have actually been taken back by the bank and they're already bank owned.
Oh.
So when you're looking at them, pay attention to what that is to know what you're doing.
Right. I see. One last question, if I may, although I have many more, but one last. So you mentioned the IRS liens. Do you have some kind of a rule of thumb there when you see an IRS lien? Let's say, I don't know, if you see above a specific sum, you say, well, I'm not bidding on that property. It's not worth it. What's the rule of thumb on it, on the IRS liens?
I'm using what I would determine to be a fair market value. And then I'm running the formula that I showed you earlier, the formula the IRS gave. And that's how I'm deciding whether or not I am going to recommend that my clients take a closer look at it. If I see that it is one of those points where the chances of redemption are low, then I'm going to say, hey guys, let's take a look at this. But if it's running through that formula and it looks like there's a chance that the property would be redeemed, then I'm not going to do it. There's one other aspect to that, and I didn't cover it because I don't have too much knowledge on it yet, but I'll just mention it here. It is my understanding that the IRS only has so much money every year they can spend on redemptions. Now, I haven't been actually able to find that in writing anywhere yet. I'm sure it's probably in some big budget bill or something, but it's my understanding that they have only a certain amount of funds they can use every year towards redeeming property.
Got it. All right. Thank you very much.
Thank you.
Thank you so much, Matthew. Anyone have any other questions, please? Any more questions? One. Gaston?
Going twice. So it's an auction.
There you go.
Thank you very much, Matt. This has been a huge source of knowledge that you have presented to us. I wasn't even aware that you can work with a title company with a sheriff. That's a big change in mind, and I'm pretty sure other audience here didn't know that fact. So yeah,
they're an excellent source of information. Yeah, use
it. Indeed, yes. Thank you very much for.
All right, thank you guys.
Casey, it's so. Casey, it's so.
I want to add that next time, maybe if Matthew would be so kind to come again, I would really be interested in knowing the procedure from the very beginning, from the homeowner's perspective. Like when does this process start?
Like the pre-foreclosure.
I mean, I know that there are many articles online about it, but it's also very interesting to know, like from the perspective of the person. Like, is it after a few months of non-paying the mortgage? What are the procedures there? Also, does the person, let's say I lose a house after it's been sold in a foreclosure, do I get something out of it? Like, do I get some money or not? So this could be also very interesting to know it from, from the other side.
Absolutely. Absolutely.
Yeah. All right. Thanks a lot.
Thank you.
All right.
Thank you, Matt. Thank you very much for your time.
Thank you so much for the
Thank
session.
you. Thank you, guys. Take care.
Have a good one. Thank you. Bye-bye.
You too. Bye-bye.